I want to thank you so much for inviting us to your wonderful country. I only hope next year it's a different time of year, but we're just delighted to be here. And I know before I launch into my talk that there's a burning question that you all have for me, so I'll answer it. And I know the question is, having seen Pat, what's a wonderful woman like that seeing a guy like you? And the answer is historical. That is back in the 70s in Berkeley, California. She saw me cruising around in my 1966 Volvo 122S with a baby blue paint job, and it was love at first sight. I want to describe for you in this next 45 minutes or so the landscape of disability rights law in the United States, and not just the laws, but the lawyers and the legal profession and how it's structured and how we interact with the disability community. But I'm going to start by echoing something that Pat just finished with, which is this took us 25 years to build. And so I want people to have that in mind as we go forward. First, let's talk a little bit about disability rights law. All right? And in the United States, it's emphatically disability rights as a civil rights matter and not as a charitable matter. And everyone talks about the Americans with Disabilities Act, which is of extraordinary importance, but you should also know that we have a rich network, a rich fabric of statutory rights that have developed over the years. So in addition to the Americans with Disabilities Act, we also have something called IDEA, Individuals with Disabilities in Education Act, that guarantees every child with a disability a free and full public education. We have Section 504 of the Rehabilitation Act, which applies sweeping anti-discrimination laws to all government agencies and not just private accommodations. We also have separately a Fair Housing Act, which requires that a certain percentage of all new and renovated housing be accessible. And then separately, we have something called the Air Carrier Access Act, which applies to airports and air transportation. Okay. So with that network in mind, it's important that we think about the ways that these statutes are enforced. And one of the ways is, of course, government agencies. The primary agency in the United States is the Department of Justice, which is centered in Washington, D.C., but operates all over the country. The Equal Opportunity Commission, which deals with, just as it says, with employment. But then we also have local laws. For example, California has a human rights law that applies to people with disabilities that is stronger and provides more protection than the Americans with Disabilities Act. New York City has a city human rights law that applies beyond the Americans with Disabilities Act. And these statutes are locally enforced as well as enforced in the federal courts. So that's the public enforcement. But then we also have private enforcement, which is what disability rights advocates is all about. And there, again, there's a network of private enforcement. There actually are only a handful of firms like disability rights advocates. And by that I mean many lawyers will handle one or two disability rights cases. There are nonprofits and for-profit firms that will handle many individual cases. There are only about, it's hard to know, but there are only about a dozen firms in the United States that are NGOs and that specialize in class action, systemic relief, and social change. And only about half of those, by that I mean half a dozen, six, specialize exclusively in disability rights law, which is what we do. All right. So the question is, in part, why not just government? And actually, one of the questions, many questions that Paul and Adolf kept sending by emails, was one that said, you know, in Sweden, people pay their taxes, they have their government agencies. Don't you trust your government? We actually laughed when we got that, Adolf, because the answer is no. All right? We don't trust the government to enforce civil rights laws, including laws with disabilities. And this isn't just a question of in any way being mean-spirited. There are some very, very good reasons why we cannot simply rely on government enforcement. All right. One is that it gets wrapped up in bureaucracy and layers of bureaucracy, which seem to get worse every year. A second result of that is the government agencies take much longer to deal. People will complain to a government agency and they'll get an action 2 years later. If a disability organization comes into disability rights advocates and has a serious problem, we will have a lawsuit on file in 1 week, right? And so they don't respond fast enough. In addition, they simply don't have enough resources. They can't be everywhere. They have to prioritize and pick some things and not others. And the government bureaucracies are often not in touch with the disability community. This is a critical part of our work. Is we're not lawyers looking for cases. We are simply the warriors for the disability community. And so we go to great pains to contact the disability community and find what they want. And the government agencies often don't do that. They're just out of touch. And finally, as illustrated by our most recent unfortunate election, the government agencies are subject to political whims. So if you have a more conservative government that's not so interested in civil rights, they're simply not going to do enough enforcement. Okay. So the question is, and I'm glad you asked those initial questions. What is disability rights advocates, and where did we start? Where are we now? Our main office is in Berkeley, California, and because, as many of you know, that's the birthplace of the civil rights movement for people with disabilities. And that's where we wanted to be, and we wanted to be in touch with the disability community. And that's still our main office. Thanks to Pat and her fundraising, we actually were able to buy our own building. So we have our own. They can't drive us out by raising the rent because we're the landlords. And so we now have a permanent home. Because New York City is not a friendly place relative to the rest of the United States for people with disabilities, 6 years ago we opened a branch office in Manhattan, and as Pat indicated, we have 6 lawyers there. All right. But that just describes the nuts and bolts. I want to tell you what the guiding principles are for disability rights advocates. And it's not just that we have a laser focus, we stay focused on systemic social change litigation, but that we have a set of principles. Number one, we want to bring cases that are important in the daily lives of people with disabilities, not just abstract legal rights, but actually affect the quality of their lives. The second thing is we are very self-consciously a cross-disability organization. So that we don't just represent people who use wheelchairs or who have ambulatory disabilities. We represent people with sensory disabilities. We represent learning disabilities. We represent psychiatric disabilities. And part of that is we're trying to constantly expand the political power and the base of the disability movement. And in recent years, we've tried to bring in groups that hadn't previously even thought of themselves as disabled. So we have brought a number of cases on behalf of low vision people as opposed to blind people. We've brought cases on behalf of the hard of hearing as opposed to the deaf, because these are growing groups. We have cases on behalf of people with diabetes who often just didn't think of themselves as disabled. And so these are the guiding principles that DRA tries to live by. And we have been quite fortunate in being very successful. And I want to talk about a few of these, all right? I don't like to talk about the few we've lost. I like to talk about the ones we've won, all right? DRA in 25 years has brought over 400 class actions, and we actually have won or successfully settled all but 6, and they fall into the following categories, all right? We have brought a series of cases on the failure to do adequate planning for people with disabilities in the event of a disaster or emergency. So we have brought lawsuits against the city of Los Angeles, against Washington, D.C., against New York City, and we've actually gone to trial on these. In New York City, we filed a lawsuit just before a terrible hurricane hit New York City a couple of years ago called Hurricane Sandy. All right. And when Hurricane Sandy hit, it hit just 2 weeks before we were going to trial. And it was living proof of what we were saying, and that seemed abstract. We had predicted that because the city had not adequately planned for people with disabilities, that if a serious hurricane ever hit New York City, the power would go out. In fact, thousands of people in wheelchairs were stranded on the 3rd or 4th or 5th floor of their apartments, some for several weeks, because they hadn't done adequate planning for people with disabilities. Okay. We've brought a series of cases, quite different cases, on behalf of both students with learning disabilities and students with low vision on testing, to provide testing accommodations, a longer period of time, breaks, different kinds of presentation in different formats of tests, both at the high school level and the college level, and application for college. Okay, we brought a lawsuit. I'm just picking a few of these. We brought a lawsuit against New York City because its famous yellow taxi cab fleet, only 2% of the cabs were wheelchair accessible, whereas, as many of you may know, London for 10 years has had 100% accessibility. We've successfully settled that suit, and we're not going to 100% yet, but over the next 5 years, we're going to 50% accessibility of the New York City taxi fleet. Okay? We've brought other lawsuits in several parts of the country because voting places were not fully accessible for people with disabilities. And in those cases, the government has responded by saying, oh, you could submit an absentee ballot, or somebody can help you with your ballot. And we have got the courts to hold that that's not good enough. You are entitled, if the general public is entitled to go to a voting place, cast their ballot in that voting place, and to do it in secret without help. so should it be there. So should people with disabilities be able to do that. I don't know. Do you have Uber here? Uber taxi cabs? Okay. So we have successfully. We're one of the few. The few law firms in the country that have successfully sued Uber. You know, it's rumored that if you go to Uber headquarters, there are 6 bureaucrats in the front and 35 lawyers in the back. They fight everything. We sued Uber because we received multiple complaints of their taxi drivers not picking up service animals, just driving right by. And we achieved a national class action settlement in which they have to train their drivers, they have to pick up service animals, they have a reporting system, they punish their drivers if they don't do it, and we have reformed that part of Uber. I don't know if you have here in Sweden UPS, United Parcel Service,
Yep.
but it's one of the biggest corporations in America. In UPS, it's one of those companies where you have to start at the bottom. Even if you're the boss's daughter or the boss's son, you have to work your way up. And the second stage up is driving their big brown vans. And Uber instituted a policy, it's such a huge corporation, it had over 1,100 deaf people, and it would not let them drive their vans, even though insurance statistics showed that the deaf drivers were actually slightly safer than those who could hear. All right, and we actually not only went to trial, we went up and down to the Court of Appeals several times till we won, requiring that UPS can't discriminate against its deaf workers. Okay. We have had several lawsuits on the question of insurance companies charging people with disabilities for both health insurance and life insurance higher premiums which were not justified by the actuarial data. So, for example, we had a case, I represented a man with muscular dystrophy, and they charged him a double premium, even though his life expectancy was only slightly diminished. And we won a decision holding that there had to be actuarial data, or they could not deny insurance. Okay. One more area that we've actually done multiple cases around the country is healthcare delivery by hospitals, physicians, and others. And Pat alluded to that with the examination table that goes up and down so a person can transfer from a wheelchair. And that came out of a case in which we sued the largest chain of hospitals and healthcare providers in California, and then we followed that up with several other cases. And I love those cases. This is a perfect example of a cross-disability case. So we brought the case on behalf of people with mobility disabilities, people who are deaf, people who are blind, people with intellectual disabilities, and every aspect of the delivery of medical services. So it isn't just the architectural barriers in the hospital, it's also the medical equipment. So when we first brought the lawsuit, the hospitals had no radiology, had no mammography equipment for people who were in a wheelchair. It was stand up out of your wheelchair and get a mammogram. They did not have examination tables that raised and lowered for people with disabilities. A very simple thing. They didn't have a scale that could weigh a person in a wheelchair. They often don't have sign language interpreters or provide captioning. And so we have brought a whole range of these suits to provide full medical care and quality treatment for people with disabilities. And I'm going to sort of stop there, but then I want to move to talking about why. It's partly why I love this work and why you can be proud to do disability rights work. And it's because almost every one of our cases doesn't just change the lives of a person with disabilities, it helps everybody, all right? So when we never bring a lawsuit without sending a warning letter first and offering to work with them. And they often, almost always, they ignore the letter, all right? Or they tell us to get lost, all right? Until we file the lawsuit. One of my favorite letters is we wrote to a major city and said, you discriminate against people with disabilities because you don't adequately prepare for people with disabilities. We've looked at your plans. And they wrote back and essentially said, we don't discriminate against people with disabilities. We don't have a good emergency plan for anyone, right? And so all of our disaster planning cases are making lives safer for everybody. One of the first it was the very first lawsuit we brought 6 years ago in New York was one of the major subway stations. The city did a huge renovation. It was $22 million. And the rule under the Americans with Disabilities Act is if you renovate, there's a special rule for subways. If you renovate a subway station, you must spend 20% on access. They didn't do it, all right? And now we sued them, and there's now what I call the Sid Wolinsky Memorial Elevator at this subway station. And a reporter wanted to see it and went with me last year. And we got off at the on the platform, and the elevator door opened up, and there was no one in a wheelchair to be seen. Out from the elevator came a very a very harassed-looking woman pushing a baby carriage with twins in it, a tourist with a huge suitcase, and a workman with a big package. So that elevator is for everybody. The many lawsuits, and we brought several of them, against cities to maintain their curb cuts in sidewalks, benefits working men and women. It benefits the tourists. It benefits the person with the shopping cart. So what's good for disability over and over again, we have found works for everybody. Now, I want to conclude with just a little overview about how well has it worked and how has the public responded. All right. Let me start with the latter. The public has not responded well to damages lawsuits. All right. And because of that, every case that I've described to you except one, all right, we do not seek damages. We bring... Huh?
What are damages?
I'm sorry?
Explain what damages
Yeah.
are.
Well, damages for the person who's injured by the civil rights violation, all right? So we bring a lawsuit for what's called equitable relief. We bring a lawsuit to fix the problem, not to pay money to the person who brings the lawsuit, all right? And we have found that receives a much better public acceptance, all right? The extent to which the ADA and these other statutes enforced by nonprofit NGOs have been successful has overall, bearing in mind it's taken us 25 years, has overall been extremely successful, but spotty. All right, so there are geographical differences. Those of you with disabilities, if you haven't been to Berkeley, California, make it your mecca. I mean, everything is accessible. It's quite wonderful. When you go to New York, it's less successful for a variety of reasons. Also, there are different degrees of success in different areas. The ADA, for a number of reasons, has not been as successful in the employment area. It's been a much tougher slog in the employment area than it has in the area of physical access. And physical access, we like to say, we've made the world flat. And it's been extremely successful there. All right. So let me just leave you with the thought that, again, this has taken us 25 years, and every one of these cases that I described for you, plus many, many more, were the first case in the country ever brought. Right. So one of the bits of feedback I've gotten in the short time we've been in Sweden and been in email exchange with Adolf and Paul have been, but you don't have case law precedents. You don't have decisions from the court. Well, DRA opened only a year and a half after the ADA had come into effect. There's nothing written in the ADA about disaster planning, all right? There's nothing written into the ADA about health care specifically and quality for people with disabilities. And I haven't even begun to describe a number of lawsuits that we brought on access to technology. And that's not in the ADA because the internet was not up and running when the ADA originally passed in 1992. So don't be alarmed at the absence of precedent. That's part of the job for the lawyers working hand in glove with the disability community to fix priorities and hopefully to make life a little better for people with disabilities. Thank you.
Thank you. Yeah. Okay, we have 5 minutes for some brief questions. You again. And then there'll be a break. There will be time for more questions later.
Yeah, Sid, could you explain how much it costs for the private individual that thinks he or she has been discriminated against? How much it costs to that person to get your services?
Yeah, nothing. Okay. We never charge our clients a fee. If the clients can afford to pay, we have a referral service, and we work with other law firms that are for-profit law firms, and we will refer them to that. But we do not. We get our funding from fee shifting, attorneys' fees that we get when we win our cases, which fortunately we do much of, and from all the funding mechanisms that Pat has described, but we do not charge our clients anything. I should add something, which is, even though technically the plaintiff, the party who's being discriminated against, and the party in the lawsuit is often an individual, we get our cases and we develop our cases working with disability organizations. We meet on a regular basis, usually 2 or 3 times a year, with independent living centers and major disability groups, and we sit down for a couple hours at a time and say, what are your problems? What are your priorities? What would you like us to do? Now sometimes we can't do anything about it. Sometimes it's a political problem and not a legal problem, but we develop those through the disability organizations, and we don't charge anybody anything.
When people approach you for help, can you take all cases, or do you have to turn back some of them?
We probably turn down 40 or 50 cases for every one we take. I always like to say to people, whether you're a profession or a business person, try giving away your services and see how good business gets. All right. And so what we do is we both work with the disability groups, and we have a litigation committee, a team of lawyers and community people on our board to select cases. Our principal criteria is impact, how much impact will it have, but we also consider other things. For example, if we've done this kind of case before, like I described, hospitals or disaster planning, well, then we can do it much more efficiently, and we're more likely to take the case.
How important is it to win all the time?
You know, I think it's of great importance to win most of the time. All right, I'm not a big fan of, nor very enthusiastic about putting in huge effort in lost causes, and that's part of selecting cases very carefully. But the one that Patricia described, the one we brought on behalf of returning veterans from the wars in Afghanistan and Iraq against the Veterans Administration, we had a huge firm meeting. We involved we not only had all the lawyers, we had paralegals and even the secretaries, because we felt it was a very difficult case to win. It was against the U.S. government, which has lots of interesting immunities, because the Veterans Administration is part of the military, and that was an extremely hard case. We knew we would not get attorney's fees because it was not a lawsuit under the ADA, and we decided to take it anyway. And as Pat said, we got suicide hotlines for people with disabilities, but you don't want to do too many of those.
There's a question in the back.
In the back.
Do you hear me? Yeah. You were talking before about not suing for damages, but suing for. I didn't really grasp the exact terminology, about equity or something.
Equitable relief. That's one of those lawyers' jargon terms.
It's just that in Sweden you can't really do that. If you sue, if it's going past the reconciliation thing, phase in the process, and you actually sue, there is only one outcome, and it's remedies that is basically paid as a compensation to the individual. So I would be very interested in knowing how. I guess it's in the law itself, this possibility, or how does it actually work?
Well, it's both in the law, that is, the courts have the power to enforce the, I'll call it social change, anti-discrimination provisions, and it's also part of the U.S. judicial tradition, which is part of the English tradition, and that is judges always have the power to order anti-discrimination or similar civil rights actions to be taken. Probably the most famous single civil rights case in the United States is the race case of Brown versus Board of Education, which was not a damages case, but essentially ordering schools all over the nation to desegregate. And it's both in the statute, and it's also a long part of the tradition.